on remedies of a breach of contract. Now, before we dive into that, I'd like to explain what a contract is. A contract is an agreement between two private parties creating legal obligations. Now, what is then a breach of contract? A breach of contract is the failure to fulfill those contractual obligations. Now then, what follows after a breach of contract? We then resort to remedies. Remedies of a breach of contract, they aim at fulfillment or termination of the contractual relationship. Now, today we are going to talk about or discuss about the remedies, these remedies of a breach of contract, and we are going to discuss the following: cancellation, damages, penalties, and specific performance.
My name is Samantha Panashe, Makope, and I'm going to be presenting on cancellation. So, cancellation of a contract is where parties legally end their contractual relationship with the intention of making the contract void. So, this normally happens when one person wants to cancel the contract and the innocent party. The law itself regards breach of contract as a wrongful act, so it allows the innocent party to cancel the contract. Then we also have what we call the cancellation agreement. It specifies the parties' reasons for cancellation, how and when the cancellation is going to take. The parties must sign the cancellation agreement. So a cancellation agreement can be unilateral or it can be by court order. It is also important to know that a notice must be given within the allotted time of the contract. That is according to the Consumer Protection Act, Section 2. So there are basic grounds of the cancellation of a contract that are set in Article 9(3)(1). It says that the other party may terminate the contract if the other party's non-performance is fundamental. Article 8(1)(6) also states that in the case of delay, the aggrieved party may also terminate the. So the Constitution may impact in some other ways, that is rendering invalid exercise of contractual powers. Maybe that is the right to cancel a contract. Pick up what I've said earlier on. I refer to the case of Botha versus Reed, where the Constitutional Court went as far as disallowing an act of cancellation for material breach, as its consequences would result to unfairness. We also have what we call a cancellation clause. It is a section which stipulates the grounds under which a contract may be cancelled and who can cancel the contract. To sum up my presentation, I refer to the Zimbabwean case of Kakumo versus Mengureni, where the court based its ruling on the Contractual Penalties Act, Section 4, Subsection 3. It also held that failure to follow the proper procedures of cancellation does not have any effect in validating a contract. A party in breach remains in breach. Thank you.
A penalty clause in a contract is a provision that obligates the defaulting party to pay some form of compensation to the innocent party in the event that a contract has been breached. With such a provision in place, the breaching party is more likely to pay the penalty to the other party instead of settling the issue in court. As much, the penalty clause serves the purpose of dissuading the other party from breaching the contract for the fear of the consequences. According to the Conventional Penalties Act of 1962, the penalty clause is enforceable by the law, and the court has also the right of comparing and reducing the compensation amount. In fact, the court is actually required to compare with the penalty clause and the amount stated to see if the amount stated compensates the damages suffered. Therefore, one must make sure that the penalty clause is not outrageous. Determining the validity of a penalty clause, the court conducts a test to see if the clause is a secondary obligation that inflicts a determination on the breaching side that is out of proportion. The court conducts the test by asking questions like, has the main objective or obligation been triggered or breached? If so, does the secondary obligation serve to protect any legitimate business obligation? Okay, so there are a number of things that need to be done to avoid unenforceable penalties, and these include considering whether the compensation or damages to be paid to the innocent party for a breach of contract are as a result of secondary obligation. If the the damages are as a result of secondary obligation, make sure that there's a legitimate interest that is proportional to the enforcement of the main obligation by the innocent party. Also avoid making the penalty extravagant, so as to make sure that the other party is able to avoid to pay the compensation in time. So we also see cases that deal with the issue of penalty clauses. For example, the Dunlop Tire Company versus the New Garage and Motors Company. We also see the case of OFT versus Abbey Nationals and others. And also there's the case of the General Trading Company versus Richmond Corporation.
Hello, my name is Vuyani Chikasha and I'm going to be presenting on specific performance as a remedy under contractual breaches. The claim for specific performance is the most basic and most obvious remedy that is used under Roman Dutch law, as it meets the expectations of the defendant when he would have entered into a contract. As contrary to English law, where one such an individual is expected to be given the primary remedy, which is that of damages. Under Roman Dutch law, the primary remedy is specific performance, and damages are only discretionary. Under specific performance for the payment of money, which is known as ad pecuniam solvendum, or in terms, or other than the payment of money in terms of a positive or a negative act known as ad factum praestendum. In South African law, the courts have taken upon themselves to exercise their discretion in terms of refusing a claim for specific performance. This may be in cases where there is impossibility and stewardship, or where the specific performance to be enforced is that of personal services. Of Haynes versus King Williamstown Municipality, there were certain guidelines that were set out in terms of the order giving of the specific performance as a remedy to contractual breaches. In that particular case, it was set out that specific performance may not be given in an instance where the defendant is insolvent, where the performance may unduly prejudice the third parties, where the performance is impossible, or where the defendant cannot. Moving on to say that where the innocent party has received part performance or malperformance and has started using that particular performance, the contract cannot be cancelled because an election to keep the contract alive has been made. In an instance where the contract has been legally cancelled and the innocent party had already used that performance they had received, that particular innocent party is now liable to the breaching party because they owe restitution for the performance that they would have used, be it part performance or be it malperformance. The innocent party is ready to perform, and the performance is objective and subjective to the remedy being sought. Instance where the specific performance that is being ordered may contradict public policy, or the performance that is being ordered is against public policy, and lastly, in an instance where it will be difficult for the court to enforce its order. Order for specific performance may be given in line with keeping of the ordinary rules of procedure. In the case of Haynes versus Williams, now I'm going to move on to the defense known as the defense may be raised against the claim of specific performance. This defense is known as the exceptional ultimate contractors rule. This rule may be raised in an instance where the contracts are supposed to be performed simultaneously, or where they are reciprocal. That is to say, in an instance where one is supposed to act before the other contractant can act on that particular action of the first individual. So this defense may be a tooling for scope procedure engineering. The court confirmed the principle of reciprocity. However, in certain circumstances, this principle may be too harsh in the data. So therefore, the court set out guidelines to determine in circumstances where the principle of reciprocity may apply. That is to say, first of all, they would consider whether or not the creditor had used the part performance that he or she had received, and secondly, whether or not there were mitigating circumstances which may garner the court's sympathy. Thompson versus Scholz, the court could not use the test that was applied in wicked tooling because the defective performance could not be repaid. Therefore, to fix this, the court applied the analogy list and gave Thompson 75% remission. The exceptional attenuate contractors maximum is available in all contracts, but however, it is not available where the breach of contract is excused by law or where the party wishes to raise the exceptional attenuate contractors. It's the one who has the risk of malperformance. Thank you so much for paying attention to this particular presentation.
My name is Samantha Manyere. I'll be presenting on damages under contractual breaches. Damages are restitutionary in nature. They aim to place the plaintiff in the position he or she would have occupied had the contract been carried out timelessly or if there had been no contract at all. These aim at compensating for financial loss or patrimonial loss. You might ask the question that what are the requirements for one to be entitled to claim contractual damages? So, for you to be entitled to claim contractual damages, there has to be a breach by the defendant. There has to be a patrimonial loss. There has to be, the breach does not have to be too remote between the defendant and the breach. When one breaches a contract, it doesn't necessarily mean that he is entitled to pay for damages. So, in this respect, the Supreme Court of Appeal held that it shall not award any physical inconveniences, any emotional inconveniences. Hence, the statement that the loss has to be patrimonial. In the event that the plaintiff suffered continuous losses, he or she has to claim for prospective loss. This is done to avoid the multiplicity of events or the multiplicity of claiming for damages. In the event of future losses, the once and for all rule is applied. This rule states that damages only have to be claimed in one action. One cannot claim for damages in multiple actions. Damages can also be calculated by using the difference rule. This states that there is a comparison between the position that is presently occupied by the plaintiff after the breach and comparing that position which would have been occupied if the contract had been carried out timelessly. Contractual damages can be calculated by determining the market value of the goods if the contract had been carried out in the exact time that it was supposed to be carried out. And also, when calculating contractual breaches, it has to be closely connected to the breach and the defendant. When determining contractual breaches, there has to be factual cause and legal cause of the breach. So, this avoids the defendant from suffering unreasonable liability. In the case of International Shipping Company versus Bentley, it is stated that for you to claim damages, there has to be a causal link between the breach and the breaching party. And also, the breach has to be closely connected to the plaintiff and the defendant. There is what we call the mitigation rule. This rule states that the occurrence of a breach does not stop the innocent party from stopping the accumulation of events. If the innocent party fails to do so, the defendant can raise a defense of mitigation. This is closely stated in the case of Victoria Falls and Transvaal Company. This is Consolidated Landlet Mines Company. Thank you. I hope this discussion was very helpful.
So the summary or the overall view of our presentation was on remedies on a breach of contract. So when we're talking about remedies of a breach of contract, like I explained, we are talking about their purpose of fulfillment or either termination of the contract. So like my colleagues explained, the remedy available when one chooses to cancel a contract, we resort to cancellation. And when one chooses to either cancel or abide by the contract, we resort to damages. And when one chooses to either
hate me, still trying to replace me, chase me, tell me how you hate me, erase me, wish you never dated me, lies, tell me lies, baby, tell me how you hate me, I bet you don't kiss her with your eyes closed, I bet you're still walking.
We'd like to thank our facilitator and our lecturer, Mr. Maphosa. Thank you very much. I would also like and love to thank Mr. Maphosa for giving me the opportunity of being the leader. I appreciate it.
So for me and my colleagues, would like to thank Mr. Nkosana Maphosa for giving us this incredible opportunity.
I want to thank Mr. Nkosana Maphosa for giving us this platform to explore ourselves.
Oh, I think Mr. Maphosa has been thanked enough. I'd just like to thank the administration and this hotel for allowing us to do this. And I'd just like to thank my colleagues they have helped me do this.
We also like to thank Flamboyant Ropa. We like all. Okay, Kata, you and Peter Banda.